All right, counsel, we are ready when you are.
Thank you, Your Honor. May it please the court, Ethan Schenkman for Appellant Conservancy of Southwest Florida. I'd like to reserve 5 minutes for rebuttal.
All right.
Your Honors, the Community Planning Act is a landmark piece of legislation. For the first time, all development projects approved by a county would have to be consistent with the county's comprehensive plan or else be deemed illegal. And how was this scheme to be enforced? The legislature created a special cause of action for citizens aggrieved by development inconsistent with the comprehensive plan. That cause of action is found in Section 3215 of the Community Planning Act, which is at the heart of this case. 3215 applies to development orders that materially alter the use, density, or intensity of use of property. The legislature gave citizens the right to challenge the consistency of such development orders in court through a de novo evidentiary proceeding. And critically, the legislature included broad statutory definitions of the terms use, density, and intensity to ensure that the scope of 3215 actions would not be unduly restricted. In this case, Your Honors, the Conservancy of Southwest Florida was deprived of its right to challenge critical aspects of the Rivergrass development because the judge refused to apply the plain text of the Community Planning Act. The trial court's judgment should be reversed for 3 separate and independent reasons. First and most important is the issue of scope. The court erroneously dismissed 2 of the Conservancy's most important claims, those relating to traffic and fiscal neutrality, as beyond the scope of Section 3215.
I want to pause just for a second. When you say dismiss claims, what you mean is, because as I recall, this wasn't a situation where you had separate standalone causes of action asserted for each of these separate theories. Rather, it's a singular claim, but different theories that are all feeding into the same claim. Am I right about that?
Your Honor, there were multiple policies in the Collier County Comprehensive Plan that Rivergrass development was.
This is a civil action, and then civil actions, we usually think of claims as separate causes of action: negligence, breach of contract, statutory cause of action under the Comprehensive Plan Act. This was a claim under the statute, but you had different theories all feeding into it, which kind of got sliced and diced in adjudication. Is that correct?
There was one cause of action, 3215,
okay.
Yes. And two of the arguments that the Conservancy made, 2 of the allegations of inconsistency, those relating to traffic and those relating to fiscal neutrality, were dismissed from the case.
So help me out, because let's go with the statute, which uses the terms. I think the applicable ones here are use or intensity of use, and you're wanting to have those silos be big enough to carry traffic and fiscal neutrality within their meaning. I guess my question is just how capacious are these terms, use and intensity of use? Let me flip it on you. Like, what in the development process, what like aspect of real estate development would not fall under use or intensity of use under the lights of how you're reading those terms?
Well, Your Honor, the focus of this case is on the definition of intensity, not use for this purpose.
Okay. So what is excluded from the term intensity within the garden variety process of developing land?
So the definition of intensity includes the use of or demand on facilities and services. And facilities and services has a very specific meaning. Facilities and services, as defined in the Community Planning Act, refers to things like potable water, wastewater, sewage, roads, law enforcement, the basic ingredients of infrastructure that are necessary for a community. And so
my question, and I'm sorry if I'm not being precise enough, because I'm still not, I've read the statutory definitions. My question is what you are trying to bring within that definition, the use of facilities and services. Arguably, anytime you take fallow land and build on it, you're going to increase the intensity of use. Does that mean any and every development, if it does anything to change an aspect of fallow land, necessarily imposes some kind of increase of intensity of use of facility and services such that it gives rise to a statutory cause of action?
No, Your Honor. I mean, for instance, you could have a requirement that houses have a certain appearance, a certain color, that they be designed in a certain way. That would not have an impact on facilities and services. For
So
facilities,
aesthetics don't really go to intensity of use of facilities or services, but
correct.
anything that's not aesthetic, you contend is properly the subject of a comp plan challenge under the statute.
Well, there has to be a policy in the comprehensive plan that it's inconsistent with. But if the policy goes to the amount or the increase of demand on or use of facilities and services as traffic and fiscal neutrality do, then it comes within, then it's cognizable under 3215. And
I may not be applying the conversation totally. Did I speak over you, Judge Lucas? No, okay. So I want to be able to follow it. Some kids are slower in the class than others. So what Judge Lucas was talking about, essentially the baseline of intensity being increased from 0, so to speak, and that would presume that the density or intensity of use, in other words, the alteration, any alteration from the baseline of intensity brings it within the ambit of the civil action. But I think, are you saying alternatively that no, that the baseline is the plan, and any alteration of the intensity which is not consistent with the plan is what brings it into the ambit of the civil action?
Correct, Your Honor. There has to be a binding policy in the comprehensive plan that puts some sort of a constraint on the demand for or use of public facilities and services. If there is such a policy and the development project is inconsistent with it, that is the type of claim that can be brought under 3215. It's important, Your Honor, for me to point out that there's really two questions on this scope issue. First question is whether the statutory definition applies. The second question is whether the Conservancy's traffic and fiscal neutrality claims meet that definition. I would point out that no one in this case disputes that if the statutory definition applies, that these claims fall within the scope of 3215. The appellees do not, neither the developer nor the county argues that. The trial court did not argue that. The amici do not argue that. What the trial court, the basis for the trial court's ruling was not that these claims do not meet the statutory definition of intensity. The basis for the trial court's ruling was that the statutory definition in the Community Planning Act does not apply to claims under Section 3215 of the Community Planning Act. And we submit, Your Honor, that has to be wrong, and it flies in the face of the plain text of the statute. The Community Planning Act has a definition section. It's Section 3164. It has it defines about 52 different terms. Quote, as used in this act, unquote. Section 3215 is part of this act. Section 3164 defines land use, it defines intensity, and it defines density. And we think that the plain text of the statute mandates that the statutory definition apply to 3215 cases. The legislature intentionally defined intensity broadly here. We have to apply under this court's precedents and under the Florida Supreme Court's precedents, we have to apply the plain text of the statute and give it its full meaning. The definition of intensity has 3 prongs to it. One has to do with the impacts on land, one has to do with impacts on natural resources, and the other has to do with impacts of development on facilities and services. Both the Conservancy's traffic claims and fiscal neutrality claims at their essence deal with demand on and use of facilities and services. With respect to traffic, Your Honor, the road system is an example of public facilities and services. And there are multiple provisions in the comprehensive plan that prohibit development that is going to place greater use on and demand for a road system than the road system has the capacity to support.
And that's I guess where I get into just how capacious is this term, because arguably by that logic, if you build a single house within a designated area and you build a road leading to it, you are now increasing traffic, right?
That's correct, Your Honor, but that doesn't make it illegal. That doesn't mean that you win your 3215 action. You have to show that there's a specific policy in the comprehensive plan that places some kind of a constraint or a restriction on the demand for and use of that service that has been violated in this case.
I'm glad, but even going back first principle though, because really what this is about is the applicability of a statute that expands standing to anyone, arguably anyone nearby, to be able to, even strangers, arguably, to be able to raise a statutory challenge to be able to use property. And so I think what I'm hearing is like, yeah, if it's within a comp plan, you build a single family home, you build a street leading up to it. Anybody and everyone could bring the statutory cause of action to challenge whether or not it's part of the comp plan. Now, what you were just responding there was, well, but they're probably going to lose because you still have to show that it's that it's violative of some provision.
Correct.
My question is, do they have a point of entry to be able to challenge that? You're building just a single family home and you're building a street connecting into it, and that the property happens to be part of a comp plan. It's open doors for anybody that wants to challenge that.
It's not 2 points, Your Honor. First, it's not
Okay.
open doors. The plaintiff does have to show that they have standing, so they have to show that
It's going to, but by the lights of your argument, that is increasing traffic. That is going to expend some additional use of facilities and services, because where there was none, now there is a family that's going to be using an additional road and spilling into it. There's your point of entry, because that's the line that you're drawing.
2 things, Your Honor. First, the plaintiff has to be injured by the violation of the comp plan, and second, they have to allege that there's been an inconsistency of the comp plan. Merely building a house, which is going to require more water usage, does not make out a 3215 claim. If the comprehensive plan says you can build 100 houses here, and they build 100 or less, I'm just as an example, then you haven't made out a 3215 claim. You have to, in order to make out a 3215 claim, the plaintiff has to identify a policy in the comprehensive plan that puts a constraint or a restriction or a limit or a cap on the demand for or use of public facilities and services that has been exceeded, violated, or not complied with, or you cannot come into court.
And walk me through then, what evidence were you not allowed to present? Let's break it up by traffic. What were you not able to present to the court for adjudication by virtue of the court's ruling?
Yes, Your Honor. The court prohibited the Conservancy from proffering any evidence relating to the capacity of the road system, the demand, the increased demand that would be placed on that road system by Rivergrass, and the county's violation.
But what evidence was going to be proffered? Did you do a proffer?
We did do a proffer, Your Honor.
Okay, where would I find that?
Ray,
the traffic. I'm just talking about the traffic.
Yeah, I can give you the record citations.
Maybe we can look for that on rebuttal.
Yes, we can find that on rebuttal. There was evidence, for example, Your Honor, that that there were deficient roadway segments that would be inadequate to serve the proposed village.
Was this the cul-de-sac?
No, Your Honor. The evidence that did go into the case that was tried had to do with the design.
Yeah.
Not the amount of use and the demand for roads. The evidence that was not allowed to come into the case had to do with whether particular road segments as part of the county's road network had the capacity to handle the increased traffic that would be generated by the number of structures and the number of people who would live in Rivergrass Village, thus greatly exacerbating traffic problems and causing an inconsistency with the comprehensive plan.
Okay, that before you said the last few words, that didn't sound at all like it had anything to do with the consistency with the comp plan. But I wanted to go back and just make sure I understand, because now you've jumped to the evidentiary, the exclusion. That I understand your argument as it relates to Judge Lucas's questions. Your argument is that it is the alteration that must be inconsistent with the comp plan to essentially state a claim under this, civil cause of action.
Correct.
Not merely that there was an alteration in the intensity of use, but that the alteration in the intensity of use itself, the alteration was not consistent with the comp plan. Is that correct?
Correct.
And then what you're saying.
I'm just going to jump in to let you know you're at your rebuttal time, but go ahead and answer Judge Atkinson's question, and I am not going to penalize you for that.
Yes, that is absolutely correct, Your Honor. There's two things that this court in Hines said you have to show to have a 3215 action. First, you have to show that the development order materially alters use, dense, or intensity. Okay, that's the first thing. That goes to Judge Lucas's point. Then you have to show, in addition, that the alteration of use, density, or intensity violates the comprehensive plan. There has to be some policy, binding policy in the comprehensive plan that's been exceeded or violated or not complied with that goes to use, density, or intensity. If you don't have that, you don't have a 3215 action. We had that in this case, and the trial court did not allow in any of the evidence relevant to traffic or fiscal neutrality. None of it. With that, Your Honor, I would reserve the rest of my time for.
Okay, thank you. How are you all gonna divide your time?
Good morning, Your Honor. My name is Sally Ashkar. I represent Collier County. The county filed a joint brief with Collier Enterprises Management, Inc., and so they will be presenting the argument on behalf of both parties this morning.
Okay, great. Thank you.
Thank you.
Good morning, Your Honors. May it please the court, Glenn Burr-Hands, Stearns Weaver Miller, representing Collier Enterprises, but as Ms. Ashkar noted, also arguing on behalf of the county pursuant to our jointly submitted answer brief. The Conservancy didn't talk about the Hine case, but let's be clear, it clearly applies here. It was binding precedent upon the trial court, and the trial court had no choice but to follow Hine in granting summary judgment with respect to both the traffic and the fiscal neutrality theories.
I understood Mr. Schenkman's argument to be within the Hine rubric. I mean, that's
Yeah,
I think that's how I heard it.
Well,
let me ask you this to one of his points.
Yes.
Assuming for a moment that the definition of intensity found in 163.3164 sub 22 does apply. Just make that assumption for, I know you've argued otherwise, but make that assumption. Why wouldn't the evidence of traffic that they presented fall under, quote, the measurement of the use of or demand on facilities and services?
Accepting that premise, Your Honor, it still wouldn't apply, and that evidence could not come in because of the express provisions in the statutory challenge at issue under 163.3215 subsection 3, which provides that the use, density, or intensity of use must relate to the particular piece of property. That's my first answer. And here, the traffic impacts and the fiscal neutrality impacts, they're not even impacts, the analysis relate to off-site issues. It doesn't relate to what's happening on the particular piece of property. And let's be clear, traffic and fiscal neutrality aren't setting caps on what you can do with the development. They're not saying you can only have a certain number of trips or you could only use certain services they have demand levels, but there are no caps. And the effect of that is that if there, with respect to traffic, if you have impacts beyond the established levels of demand, then you have to pay for mitigation. So it's a way, both traffic and fiscal neutrality are a way of figuring out what's the cost on the system. And if the cost kind of exceeds the level of demand in traffic, or the costs exceed the revenues generated by the tax revenue, then you have to pay more. On the fiscal neutrality side, it might be more in impact fees. On the traffic side, it might be you have to pay to mitigate impacts. But it's not, as council suggested, that they're capping as to what you could do on the development. And that's why none of this should come in, because the statutory scheme under 3215 contemplates material alteration of use, density, or intensity on the particular piece of property at issue. Now, we're not arguing, by the way, Hein got it right in establishing the definition in a .3215 consistency challenge context, because there the court stated that intensity was the increase or decrease in the number of structures on a particular piece of land. Now, frankly, that's completely consistent with the first clause in section 163.3164, subsection 22. But that's not the beyond though, because the statute doesn't contemplate judging consistency with a statutory definition. 3215 is based solely with determining consistency with respect to the comprehensive plan as adopted. Now here, and it's undisputed by conservancy, here the comprehensive plan defined intensity as the maximum floor area ratio as set forth in attachment C within the comprehensive plan. That, by the way, goes to the increase or decrease in structures on the piece of land, which is consistent with Hein. As I said, is still consistent with the statutory definition, but you have to look at the particular context of how the GMP is regulating intensity on that particular piece of land. That's the plain language of subsection 163.3215, and we can't ignore that. As this court held in Hein, we can't rewrite the statute to add words that aren't there, like engrafting the definition of subsection 22, which didn't happen here. And we can't eliminate words that the legislature did put there. And by the way, if the legislature wanted subsection 22 to specifically apply to intensity of use in 3215, it would have specifically cross-referenced that definition, just as it did in the.
I'm not sure that dog hunts. Because I'm looking at it, the statutory cause of action that we're all talking about is part of chapter 163. And section 163.3164 begins with as used in this act. I'm not sure how you're able to say, well, but they didn't specifically cross-reference it when they specifically referenced the term for the entire act, and 3215 is part of the act.
Well, Your Honor, in 3215, the legislature specifically referenced development order, quote, as defined in section 163.3164. I don't have to debate that point with you. I respect your opinion. We don't need that to win, because the statutory cause of action as established by the legislature, and we can't expand the statutory claim. We have to limit it to the plain language of 3215. 3215 defines the scope of the claims as the development order materially altering the use, density, or intensity of use on the particular piece of property, and which is not consistent with the comprehensive plan adopted under the act. That's why you have to go to the comprehensive plan provisions to see how the terms are, the standards are set forth. With respect to intensity, the only standard set forth is the maximum floor area ratio referenced in attachment C.
So forgive my question, I posed it to Mr. Schenkman, and forgive me for not having it off the top of my head, but this was kind of a voluminous case in terms of what we've got before us. Can you hone me in on where I would look at to see what evidence was proffered and excluded and not adjudicated vis-a-vis traffic that would assure me that the trial court below made the statutory parsing that you're making now, which is to say, the Conservancy came forward with this evidence. The judge held it should be excluded because it did not pertain to intensity of use on this property. Where would I go to find that kind of distinction that you're drawing?
Your Honor, forgive me. The Conservancy's proffer on traffic and fiscal neutrality is in the record. That is their case. I can't. There was a proffer made at the close of the evidence, I should say. It's very voluminous. But with respect to the evidence that was excluded, with respect to traffic and fiscal neutrality, those claims were appropriately adjudicated on summary judgment, and no evidence relating to those things that came in. On the motion in limine, the court appropriately excluded parole evidence.
That's right.
So
the summary judgment evidence that was considered wouldn't have even included a proffer. It would have just been whatever they put forward in affidavits in support of summary judgment or deposition transcripts. That's what we would be looking at in terms of whether or not that was appropriately adjudicated.
Well, yes, on summary judgment, and with respect to whatever the effect was on the evidence at trial. Now, I do know that the Conservancy did make an extensive evidentiary proffer at trial that included, I think, all of this stuff. I think it lasted for a few hours, if I'm not mistaken, once the evidence was closed. Now, so, Your Honor, you had asked earlier on, how capacious is the cause of action? And not very, because we have to look to what the comprehensive plan says. In this case, with respect to intensity of use, the Conservancy doesn't challenge use or density, and then use relates to the permitted land uses, residential, retail, etc. And density is not at issue. So we're only focusing on intensity of use. Under the Conservancy's theory, any person could challenge any aspect of a development order for any reason. That's how broadly they want to read that, including bringing in materials that are not part of the comprehensive plan, such as elements of the Land Development Code, which were not incorporated into the comprehensive plan, which under controlling case law, in Little Club in particular comes to mind, I think Buck Lake as well. The Land Development Code regulations are separate from the comprehensive plan. They are ordinances that implement the comprehensive plan, but they are not part of the comprehensive plan. As a matter of fact, the Conservancy's experts conceded that at trial. So the LDC claims do not come into the case because they're not part of the comprehensive plan. Now, if the county wants to expressly incorporate the Land Development Code into the comprehensive plan, it can do so, but it must follow section 163.3177, which didn't happen here. So, Your Honor, the Conservancy is really asking the court to adopt a rule that would, and by the way, counsel got the standard for standing wrong. It's not that you have to show an injury. That's the Renard standard, which would apply in a certiorari challenge. That's not the case here. As you noted, Judge Lucas, the standard for standing is very low here, but that doesn't mean that the claims are unlimited, as this court specifically found in Hine. Now, the other reason why we don't need to resort to section 163.3194 or even 163.3164, I submit, is because the text of section 163.3215 sub 3 is clear and unambiguous as found by the Hine court. And if Mr. Shankman and the Conservancy are arguing that Hine applies, then they must be agreeing that the language of the statute is clear and unambiguous. Therefore, we don't have to resort to any of the machinations of statutory construction that's urged in the briefing, particularly with respect to the Imhoff decision. So
I understood Mr. Shankman's argument to just be for the sake of, I don't think he's abandoning any of his arguments in the briefs. I think he's just making the argument under the Hine standard because, frankly, that's kind of what we've been pitching at him.
Mhm.
is to understand it in that rubric, but I don't understand him to be dropping that.
Well, Your Honor, I'm not suggesting he's dropping or waiving anything. I'm saying part of his argument was consistent with Hine, which would inform us that the statute is to be looked at as clear and unambiguous.
Well, I think he understands that we're bound by that. So he's framing his argument,
Thank you,
given
Judge.
that fact.
Thank you. So I would like to point out a couple of other aspects that I think are problematic with the Conservancy's attempt to use the statutory definition of intensity without context of section 163.3215 and without context to the actual GMP. I've already
Let me
explained
pause you real
why.
quick. What is the GMP's definition of intensity of use again?
So, Your Honor, that is found in attachment C, which is a chart that sets forth objective criteria or objective measurements, if you will, which is consistent with the statutory definition, but it's found at record page 1036. And this is the specific RLSA overlay area regulations. So when section 163.3215 is talking about consistency with the comprehensive plan as it relates to intensity of use, this is precisely the document we need to look at. And that's precisely what the court looked at, because you'll see on the third line down in this chart under the characteristics of a village, it speaks to maximum floor area ratio or intensity. Now, that simply is a measure of the non-residential structures by area versus the overall area of the development. It's an objective measurement, which is consistent with Hine, which is consistent with the statute as well. So that's where you would find it, Your Honor.
So if the comprehensive plan said, for the purposes of this plan, intensity means, and only means that each lot can be permitted only 10 sprinkler heads and no more, and it's a totally sprinkler head centric definition of intensity. The other aspects of intensity under 163.3164 subsection 22, such as measurement of the use of land, use of or demand on natural resources, only has to do. We only measure intensity by the number of sprinkler heads you're allowed to have in the comprehensive plan. So in other words, the comprehensive plan's definition of intensity controls over the definition in the chapter. Is that right?
No, Your Honor, I disagree. Those other clauses in subsection 22 would agree if there was a comprehensive plan provision that specifically addressed those aspects on the particular piece of property, because that is the scope of the 3215 claim. In that rubric,
You're saying that you're agreeing that it could be broader, that the comprehensive plan cannot narrow the definition narrower than it is as described in chapter 163. But you're saying it would 163.22 itself confines use or demand of natural resources to those natural resources right there on the property?
yes, Your Honor, what I'm suggesting is that it's a context-specific inquiry. So you have to start with the framing of a claim under 163.3215 relates to, and I'll just say, intensity of use on the particular piece of property. That's the exact statutory text. We have to give that full force and meaning. Now, if the Collier County GMP had provisions that called for intensity of use with respect to the natural resources or intensity of use with respect to the demands on services on the particular piece of property, then I would agree that would come within the scope of the claim, but that is not what we have here.
Okay, I understand. In other words, the intensity itself, the term is, to use Judge Lucas's just descriptor, capacious enough to include whatever uses of or demands on natural resources are described in the plan. But if there are none, then you can't bring in evidence of use of or demand on natural resources unless the plan touches on that. But you also qualified by saying on the property, which is like one of the troubles I have is on the well, what if the comp plan says, generally use of or demand of natural resources?
Your Honor, respectfully, I'm not qualifying it. The Florida legislature qualified it when they wrote in the statute on the particular piece of property. So we have to give the legislature's words as written their full effect. The only way you can reasonably read that to mean is, and let's put it in context, that we are determining consistency as against the adopted comprehensive plan. So the comprehensive plan, to the extent, as you put it, to the extent it expresses a measure of intensity of use that goes to the increase or decrease of the property or the demand on natural resources or the demand on services on the particular piece of property. If the GMP provides for that, then it would come within the scope of the statutory claim.
And that ties into 3215 insofar as our court has held that the three qualifiers that give you a statutory cause of action have to be related to an inconsistency with the comp plan.
Correct, Your Honor.
That's one of the antecedent, or I forget, one of the conventions that is included in there is that it does indeed have to be inconsistent with the comp plan.
That's the whole thing. We're already talking about consistency with the comp plan. Now, mind you, whatever provisions that are made in the comprehensive plan as it relates to use density or intensity of use, let's focus on intensity of use, certainly cannot be inconsistent with the statutory scheme. But that's why I noted earlier here, Hines' construct of looking at the increase or decrease of structures on the piece of land is still consistent with subsection 22. Judge Hayes's construct using floor area ratio as specified in the GMP is still consistent with Hines and the statute. So it really does all fit together. We're not, as the Conservancy is suggesting, trying to argue some different or out there definition of intensity. We're following strictly the statutory scheme. You start with the claim under 3215, limited to intensity of use on the particular piece of property, and then you look to how the GMP addresses that. Now here, the fiscal neutrality provisions and the traffic provisions are not relating to the particular piece of property. They may draw upon data relating to that development, but again, as I said earlier, at the end of the day, for both of those aspects, you're only talking about how much money is a developer going to have to pay on the back end, whether it's going to be more impact fees, whether it's going to be more money to create a new traffic signal or turning lane or so forth. It's not capping what the developer can do with their own property.
Are you making two arguments about those provisions? In other words, one that they don't go to density or intensity on the particular piece of property, and even if they did, they would, a certain use would not be inconsistent with the comprehensive plan because the comprehensive plan just contemplates that if you exceed a certain level, you just pay for it. Are those two separate arguments?
Well, I think they could be characterized as separate, but I think they fit together, Your Honor. And I want to add one other thing. With respect to fiscal neutrality, the way that is analyzed is there's a couple different methodologies that you kind of can choose and pick from that are found in the Land Development Code. And that's another reason why fiscal neutrality has no part here, because that becomes a land use code analysis. And as the Conservancy's experts even agree, the Land Development Code here has not been incorporated into the GMP. At the end of the day, Your Honor, the Conservancy—
Sir, I'm going to ask you to wrap it up, please. You're at the end of your time.
Thank you, Your Honor. I will. At the end of the day, Your Honors, the Conservancy is asking you to open up the statutory claim, which is narrowly enumerated, to broad-ranging attacks that could bring in elements that are not expressly stated in the growth management plan. In essence, they want you to allow challenges by anyone for any reason based upon standards that are not even contained within the growth management plan. That is directly contrary to the plain language of section 163.3215, subsection 3. Thank you.
All right, thank you. Mr. Shankman, rebuttal?
Yes, Your Honor. Just quickly, something to clean up on the record. At record page 2523, you'll find the Conservancy's motion for summary judgment on traffic and fiscal neutrality. That's where it starts. And all of the evidence that was attached there too was not admitted into the case. And at record page 9501 is the proffer that the Conservancy made of its evidence that was not admitted into the case.
So to get to Mr. Burhan's point, what chapter and verse in the GMP would I look at to tell me these are the traffic thresholds and fiscal thresholds that the evidence outlined at record 2523 in the motion would have pertained to?
Yes, so with respect to fiscal neutrality, Your Honor, GMP policy 4.18 requires that the development must be fiscally neutral or positive to Collier County at the development's build-out date. And this must be done through a public facilities impact assessment, which studies the impact that the development will have on.
And was that assessment done and filed before the trial court?
No, Your Honor, because all of the evidence relating to fiscal neutrality was excluded from the case.
Okay.
That goes to the merits. And
Would I be
Your Honor,
correct in arguing that, just so I'm following it, would I be correct in arguing that even though that is in the comp plan, and I'm sorry, Ms. Burhans doesn't have a chance to respond to my comment that reveals some ignorance, but that is not intensity on a particular piece of property, but rather intensity as it pertains to something extraneous to the property?
No, Your Honor, it absolutely is intensity on the piece of property, because the use of and the demand for the facility is generated by the uses on the property, by the structures on the property, by the people who will be living on the property, by the cars that will be on the property, et cetera. So, for example, with respect to fiscal neutrality, Your Honor, one of the Conservancy's pieces of evidence was that as a result of the massive increase of demand for potable water, the county would have to build a new potable water facility. It should not matter for purposes of the definition of intensity whether that potable water facility will be built on the Rivergrass Village or off-site from the village.
But I think what he's saying, what I think he's saying, and I apologize, he can't respond now, but is that's fine. That might very well be inconsistent with the comprehensive plan, but it is not an inconsistency that is due to an alteration of the intensity of use on the particular piece of property.
It is, Your Honor. It's due to the number of houses, the number of commercial facilities, the number of people who live there, the number of cars who will be using these facilities, all on the Rivergrass property. What the fiscal neutrality requirement provides is that the cost that is imposed by that increased demand cannot exceed the revenue to the county that's generated.
You're saying that comp plan says the intensity of use on this particular piece of property cannot exceed a certain cost. Exactly. That would burden facilities and structures and stuff off this property.
That is the allegation, Your Honor, and most of Mr. Burhans's argument went to the merits. Our point is that the Conservancy did not have its day in court to argue about what the fiscal neutrality provision means, what it entails, how it's applied to this case, and how it was violated. No evidence, no argument on the merits. The only thing that we're asking this court to do is to allow the Conservancy its day in court to make the arguments, Judge Atkinson, that you just outlined. I would like to respond to the attachment C argument, and that's where Mr. Burhans argues that it's the definition in the comprehensive plan of intensity that should control here. 2 points to that, Your Honor. First of all, that gets the law backwards. The comprehensive plan cannot trump the statutory definition of intensity. Anything that relates to the statutory definition of intensity that's in the comprehensive plan that has been violated or not complied with is fair game in a 3215 action. But in addition, Mr. Burhans just completely misspoke when he said that attachment C contains a definition of intensity. There's no such definition. Attachment C merely lists typical characteristics of a town versus a village versus a hamlet. It is by no means a list of every policy in the comprehensive plan that relates to use density or intensity, or a list of every policy in the comprehensive plan that can be brought forward in a 3215 claim. So that it just attachment C doesn't stand for what Mr. Burhan says it does. You know, Your Honor, at the end of the day, we agree with appellees that it's the plain text of the statute, the plain language of the statute that should control. And there's no need to resort to canons of construction in this case. The definition of intensity in section 3164, Your Honor, is broad. That's the plain language. And you know, the Conservancy does not shy away from the fact that it is broad. The legislator wanted it to be broad. And no one in this case disputes that if the statutory definition applies, that the Conservancy's traffic and fiscal neutrality claims do fall within the scope of 3215. Again, Your Honor, the Conservancy would only ask that it be allowed to submit its evidence and make its arguments on the merits with respect to the constraints that these policies place on intensity on the property. If Mr. Burns is correct on the merits, then the Conservancy won't prevail at the end of the day. But all we ask for, Your Honor, is for our day in court, consistent with this court's decision in High.
And were there, I'm sorry, I know you're out of time. I've just got one final question if I can, Judge Kelly.
That's fine.
Thank you, I appreciate it. Real quick, Mr. Shankman. I am assuming, and again, I don't have everything memorized here, but I am assuming that the evidence of the proffer is similar to the evidence that was put before the court on the motion for summary judgment. Is there anything because your final argument is, hey, on remand, we just want our day in court. But it seems to me that evidence was considered by the court at the motion for summary judgment. What about the character of the evidence was such that it should not have been adjudicated at summary judgment, but rather by a trial?
Your Honor, there would have been expert testimony, for example, on both traffic and fiscal neutrality that was never allowed into the case. And
but was that part of the summary judgment record?
Some of it was, but not all of it, Your Honor. And none of the. I do want to point out that
I'll have to take a look. I'll have to take a closer look.
The evidence. Just one thing for clarification, Your Honor. Our third point here was the judge's ruling on the motion in limine, the evidence that the judge excluded. That evidence only goes to the claims that did go to trial.
Yeah. That
evidence does not go to fiscal neutrality or traffic, which, Your Honor, is correct. You would find attached to our motion for summary judgment on traffic and fiscal neutrality.
Okay.
All right. Thank you both. Thank you all. That concludes this argument, and it concludes our docket for today. Court is adjourned.